Assalamu alaikum and good day to all the participants. I, Aslam Mayat, am moderating this webinar on behalf of the Association of Muslim Accountants and Lawyers. Amal prays for all who are suffering or who have succumbed to COVID. The panel will talk for 90 minutes. It's a Q&A session. At the end, 30 minutes are set aside for the panel to answer written questions or comments. So if the listeners can please start writing in their questions and comments in the question box that is on your screen. Calls for Muslim Marriages Law, commonly but incorrectly termed MPL, started at the time of Minister of Justice Dalla Omar. Our constitution obliges our government to recognize religious marriages. Non-recognition of Muslim marriages infringed on our right to dignity. Many Muslim wives applied to court claiming that such non-recognition resulted in their oppression and unfair discrimination. The very first successful case in this regard was argued by our esteemed panelist, MS Omar, an expert in both South African and Islamic law. MS claimed loss of support for a widow against the MVA fund. The Concord, headed by Chief Justice Ismail Mohammed, granted relief to the widow. Despite numerous cases, our courts withheld legal recognition, but have instead, on a case-by-case, piecemeal, incremental basis, given the same consequences afforded to civil marriages to Sharia-only marriages. This band-aid palliative was not the cure. There have been two main opposing MPL camps. UQSA and Amal support a Muslim Marriages Act, whilst conceding that legislation may not be in accordance with the belief of every Muslim. This pro-MPL lobby contended that the proposed draft Muslim Marriage Bill, MMB, not to be confused with MBS, was in line with legislation of Muslim majority countries internationally and with our constitution, and the harm of not having legislation was too great. On the other hand, KZN Jamaat and the Muslim Lawyers Association contended that government must simply recognize Muslim marriages. By going any further, there would be legislative, un-Islamic contamination, which they would not be party to. The Women's Legal Center has been at the coalface of the struggle for Muslim wives. In 2009, they applied to the Constitutional Court to compel government to pass legislation. The Concord ruled that the case should be ventilated first in the lower court. United Ulama Council, UQSA, represented by MS Omar, the Coalition of Muslim Women, represented by Munirah Osman, Women's Cultural Group, represented by myself, were all admitted as friends of the court and made submissions. Amal, of which Munirah and I are EXCO members, was also admitted as an amicus. So some of the suspects at the Concord, whose photo was shown earlier, are on this webinar and will unpack the groundbreaking judgment. The SCA order can be broken up into 5 parts. Some already in operation, some subject to Concord confirmation, some to be put in place in 18 months, and others suspended until confirmed by the Concord, and even then will apply after 24 months only if government fails to pass legislation recognizing Muslim marriages. Some retrospectively, others only from the date of the order. Now, we need to put a disclaimer. People must be guided by their own legal advisors and must not take legal action based on what they hear or imagine they heard on this webinar. Attorney Sheikh MS Omar has been involved in MPL from day one. He was on the Law Commission, and his input at the SCA was of great assistance to the court. Shoaib, given the admissions made by government lawyers, what is the possibility of appeal by government other than the undertaking given by the minister? Does every part of the order have to first be confirmed by the court before it takes effect? Over to you, Shoaib.
Jazakumullah, Aslam. Bismillahirrahmanirrahim. Nahmaduhu wa nusalli ala rasulil kareem, amma ba'd. Judgment itself is very far-reaching, and coming back to the points you've raised, if you look at the order granted by the SCA, paragraphs 1.1, 1.2, 1.3, and 1.4 relate to declarations of invalidity. In other words, the Marriage Act and the Divorce Act have been declared to be inconsistent with certain provisions of the Constitution, more particularly the equality provisions, the dignity provisions, and the best interest of the child provisions, and access to justice provisions. On the basis that they fail to recognize marriages contracted in accordance with Sharia law as valid marriages for all purposes in South Africa, and to regulate the consequences of such a recognition. What is important to understand here in understanding this order is that we are dealing firstly with only Islamic marriages. That is, marriages contracted in terms of Sharia law, which have not been converted into civil marriages. So the order makes that clear. It says that we are dealing with purely Islamic marriages, which have not been registered as civil marriages. In relation to these Islamic marriages, there's a declaration of constitutional invalidity. So the orders, as indicated to you, of constitutional invalidity are set out in paragraphs 1.1, 1.2, 1.3, and 1.4. These orders, and this comes back to the question that you raised about whether the state can appeal these orders. In my humble submission, the state cannot appeal these orders because the state made a concession during the course of legal argument that the Marriage Act was unconstitutional, the Divorce Act was unconstitutional, Section 6 of the Divorce Act was unconstitutional because it failed to provide for adequate safeguards for the welfare of minor or dependent children. Section 7.3 of the Divorce Act was unconstitutional insofar as it failed to provide for a just redistribution of assets within an Islamic marriage. And Section 9.1 of the Divorce Act was unconstitutional for failing to provide for a forfeiture of patrimonial benefits at the time of the dissolution of a Muslim marriage. Now, what is important to note here is these declarations of invalidity firstly relate to the failure to provide, as the court order says, similar protections for Muslim marriages. So the wording is in the same or similar manner as it provides mechanisms to safeguard, for example, the welfare of minor children of other registered marriages under the Marriage Act. So it's the same or similar manner. So the effect of paragraphs 1.1 to 1.4 is these orders require to be confirmed. These orders of constitutional invalidity are now referred to the Constitutional Court for confirmation. And again, to come back to the point you raised, the state will not oppose them because the state made the concessions in the first place. 1.1, 1.2, 1.3, and 1.4 is effectively in line with the draft order that the state proposed to the full bench of the Supreme Court of Appeal. And because agreement could not be reached on the precise terms of those orders between the main contending parties, that is the Women's Legal Center Trust and the state, the court had to actually finalize, or at least adjudicate precisely what the terms of these orders are. But
okay, so basically the state made admissions. It was
yes,
a consent order which all the parties more or less agreed to. So the chances of an appeal are
no, the chances of an appeal by the state are non-existent.
However, those invalid in terms of the constitution would need to still be confirmed by the Concord.
Which should be a formality, Aslam.
Formality.
It shouldn't be.
Yeah.
And you look, there may be a cross appeal from the Women's Legal Center Trust on a different issue, whether the state breached its Section 7.1 constitutional obligation, which is a separate issue, but the effect of the orders in paragraphs 1.1 to 1.7 of the judgment of the SCA is exactly the same, whether the state breached its Section 7.1 obligation to pass legislation recognizing Muslim marriages and their consequences for all purposes or not. But this is the net effect, 1.1 to 1.7. Then, of course, the next part of your question goes into the interim relief part. And as far as the interim relief or the temporary relief provisions are concerned, in my opinion, they don't require the consent of the Constitutional Court. The Constitutional Court does not have to confirm paragraph 1.8, which is very critical for the purposes of our discussion today.
Okay.
Because
we're going to come to 1.8 as we go along.
Right.
If we can go on to the next question. Just a note of caution, all the extracts of the order which will appear on the screen have been redacted. Munirah Osman is a senior lecturer at UKZN. Munirah, what would be the effect of an application to vary the SCA order? Would the case drag on or only certain parts of the order? Because the order 111 says that if administrative or practical problems arise, a person can apply to the SCA to vary the order. Munirah?
Yes, shukran for that question, Aslam. Well, really what we're saying here is that generally when courts make any orders, one could actually apply for a variation of that order. And so here the court is being very, very specific in terms of what can be varied. So if you look at it, it's saying very clearly as you read it out that if it is an administrative or practical problem. So that means that we're not going to go back to court and have especially 1.1 to 1.4 varied, because those are declarations of invalidity. And as Shuaib has just explained, that's going to go on as a formality to the Constitutional Court for a declaration of invalidity to be confirmed. But if we look at this particular order, then perhaps 1.8 is one of those particular orders that can be brought up as a subject of variation, the one dealing with the divorce, etc. So we must be very, very clear that not the entire order can actually be raised to be varied, but rather very specific parts of the order, and that to those parts of the order that actually deal with some kind of administrative issue or where there is some kind of a practical problem that will be arising out of this particular order.
Okay, so basically the legal part of it is not is out of the way. That's been decided, but just practical problems that obviously the court would not know in a particular case, which would need to be dealt with. If we can go on to the next question. The common law definition of marriage is invalid to the extent that it excludes Muslim marriages. Advocate Aslam Bava, senior counsel and acting judge, heads the Amal legal team, Manco member of the Arbitration Foundation of South Africa. I had actually wanted to be on the panel, but Advocate Bava shanghaied me. Incidentally, he participated in the Shanghai 14 or China-Africa Joint Arbitration Center initiative. Advocate Bava, what is the effect of the declaration by the SCA that the common law definition of marriage is invalid to the extent that it excludes Muslim marriages? Is para 1.6 also suspended until confirmed by the Concord? And are Hindu and Jewish marriages, etc., affected by this order? Advocate Bava? Can you unmute yourself, Advocate Bava? You're muted.
Thank you. Thank you. I was saying in my muted state that perhaps we should avoid confusion by calling you Aslam, and I'll just call you Chairperson or Mr. Mayat. So that
Mayat is good enough.
Okay, Mayat is good enough. Excellent. This is a very important question, and I think perhaps we want to take a step back firstly to understand what we know to be the common law. Many people struggle with the concept of what constitutes the common law. And sometimes we as lawyers take it that everybody should or knows or understands what the common law means. So I'm just going to take one step back firstly to explain to us what the common law is. And there's a very nice definition as to what common law is. So you have two types of basically fundamental aspects that regulate our law or constitute our rule of law that we have to abide by. And one is statutory and the other one constitutes common law. Common law is a body of unwritten laws. That is the first important aspect. And it is based on legal precedents established by the courts. So if there is no statutory provision, then courts look at what should be applied and how the law should be applied, and they make rulings, and that constitutes a body of unwritten laws that govern us. And so common law therefore influences the decision-making process in cases where the statutes are not or do not prescribe, and where the common law prescribes, or where courts have held it in the past. So that is firstly very important to understand. Once we understand that proposition, then we come on to finding out how profound the effect of paragraph 1.6 is. And the paragraph 1.6 of the order declared that the common law definition of marriage is invalid to the extent that it excludes Muslim marriages. Now, this is a long fought, hard fought battle. And I must say for myself that I'm very glad that this has now resulted in the decision in the Supreme Court of Appeal, which is to my mind a very well written decision. But I must preface that by saying it has only been through the struggles of lawyers and of individuals who have been dedicated to the cause of bringing justice to Muslim women and Muslim children, particularly. And so the effect of that is that in terms of the common law, Muslim marriages now are on par with other legally recognized, so statutorily recognized. So now the common law in terms of section 173 of the Constitution is to be developed by all courts. And taking that into account is that firstly, it is not suspended and it's not dependent on the constitutional court confirming its validity, because the Constitutional Court is only called upon to determine the validity in terms of section 167.5 of prayers 1.1 to 275, paragraphs 1.1 to 1.4 of the order. This is paragraph 1.6. So it is not suspended until confirmed by the Concord. It is of immediate operation. The aspect is whether it will affect Hindu and Jewish marriages. The point is that because courts have to develop the common law, and they're obliged to in terms of the Constitution, in terms of section 173, it will put a spin, and it definitely a positive spin in respect of any prejudice or any unfair discrimination that is suffered by any parties in respect of Hindu, Jewish, customary, or other marriages.
Okay, thank you very much. We can go on to the next question, which is SCA Order 1.9, which says that Section 12 of the Children's Act applies. To summarize, boys under 14 and girls under 12 cannot marry. Boys under 18, under 15 require ministerial consent. Munirah, is this part already in operation? And can you explain what it means?
Okay, shukran again, Aslam. Yes, this particular part of the Children's Act is obviously in operation. And I will just repeat very, very quickly what you have said as well, just to make it very, very clear correctly, that boys under the age of 14 and girls under the age of 12, and Aslam, take note of these ages, right? Basically means that girls mature faster than boys, right? That's why the ages differ. Okay, I just thought I'd bring that to everyone's notice. But anyway, so boys under 14 and girls under 12 cannot marry at all. So what it's basically saying is that that portion of the Children's Act will now also apply to Muslim marriages, and where in Muslim marriages, those persons who are wanting to get married fall within this age group, then they will not be able to get married, because now, as Aslam Bava has just explained, that Muslim marriages are now regarded as a part of the common law definition of marriages, and therefore all else will fall into place. So that is absolutely correct, and that will stand. Then it is adding on that should the boy be under the age of 18 and the girl under the age of 15, then there are certain consents that are required. In addition to the parties consenting, we are going to require ministerial consent together with parental consent. So there's these levels of consent that is actually going to be required at this. And this is obviously already in existence in terms of Section 12, subsection 2 of the Children's Act. So basically what they're saying is that that section of the Children's Act will now extend to parties who are intending to get married in terms of a Muslim marriage. Did you want me to go on about, I know we raised the issue of engagement.
I'll come to that. Munirah, you know, my wife says that husbands never mature, but we'll leave that out for the time being. I cannot find a definition of engagement in the Marriage Act.
Okay, well, that's simply because it's not a statute.
I just want to know, what does given out in engagement mean in the context of Muslims? What does it mean? Drinking sharbat or what?
Well, you see, in terms of Muslims, there isn't really a formal procedure for an engagement. Even in terms of South African law, there aren't formal procedures in terms of how an engagement takes place. We follow common law definition of what engagement is in terms of South African law. And that's basically saying that there's certain requirements that will add up to make the fact that an engagement has been taken place. So there's an agreement to marry, okay? and that agreement is between a man and a woman, of course, now that stands to be questioned in terms of the Civil Unions Act. And then that this agreement to marry between a man and a woman has to happen within a specific or a very determined date or a reasonable period. So that's what the common law principles are in terms of a requirement for an engagement. So I'm thinking that if we apply these requirements in a situation of a so-called Muslim engagement, then if these requirements are met, then in terms of the common law, what we have is a valid engagement.
Okay, we'll go on to the next question, which deals with Order 1.10. For children, certain sections of the Customary Marriages Act applies to Muslim marriages. Now, the Customary Marriages Act requires both parties to consent and to be 18 years or older. Both parents or legal guardian must consent for a minor, failing which the minister consent if it is in the interests of a minor. Now, Shoaib, is this part already in operation? Does this mean that a major female can marry without wali consent? And if you could just explain the effect of para 1.10 of the order.
Okay. Bismillahir Rahmanir Rahim. Yes, basically what if you look at para 1.9 first, it says that it is declared that from the date of this order, Section 12.2 of the Children's Act applies to Muslim marriages concluded after the date of this order. So this means that 12.2 says that the prospective spouses must be over the age of 18 years. At least the minimum age for marriage is 18 years. And then what it then does is it applies the provisions of the Recognition of Customary Marriages Act, Sections 3.1a, 3.1a, 3.3a, 3.3b, 3.4a, and 3.4b, and 3b of the Recognition of Customary Marriages Act, mutatis mutandis, in other words, to Muslim marriages, subject to the necessary changes. And this is recorded in paragraph 1.10. As Munirah earlier on stated, essentially what this means is that if the prospective spouses are under the age of 18, they require the consent of the parent or legal guardian, as is contemplated in Section 25 of the Marriage Act 1961. And if that consent cannot be obtained, then of course the minister has the power to grant the consent. And so all we're doing is we're just applying the procedures, the regulatory procedures set forth in the Recognition of Customary Marriages Act to Muslim marriages. And obviously this will apply until the contemplated legislation, which has to be passed within 24 months. So once either the existing legislation is amended or new legislation is passed within 24 months of the SCA order, then that legislation may deal with the same issue. In other words, the question of prospective spouses who are under the age of 18 years, and what kind of the parental consent will have to be obtained first, and failing the parental consent, the ministerial consent. And a similar provision was incorporated in the draft Muslim Marriages Bill, which you alluded to in your introduction. So this is just to bring the legislation in line, not only with the current statutory provisions, but also the international treaties and conventions relating to the minimum age for marriage.
Okay, so the question is wali consent that wouldn't, for major females would not apply, correct?
Well, in the Hanafi school of law, in any event, if you take the Hanafi school in relation to the other schools, that is the Shafi'i, Maliki, and Hanbali, in the Hanafi school, You don't need, if a female has reached what we call bulugh or maturity, then she can consent to her own marriage. She doesn't require the consent of her guardian,
Okay.
which is very practical from, which is, I would think, very much practical for today in contemporary situations.
And would international, because quite a Muslim marriages has been introduced in many Muslim majority countries as well. Is that how they formulating their statutes regarding consent?
To the best of my knowledge, yes. I think they generally follow the Hanafi school, and also their legislation is in line with the international treaties and conventions, to the best of my knowledge.
We now go on to SCA Order 1.8, which says that pending legislation, the Divorce Act applies to all existing Sharia marriages. In absence of a contrary agreement, Muslim marriages are out of community of property. Section 7.3 of the Divorce Act applies. And if a husband is party to more than one Muslim marriage, then the court will make an equitable order and join any interested party. Order 1.8, which relates to condition in 24 months. And I think, subject to correction, this is really the crux of the matter as far as the Muslim Ummah is concerned. And all the lawyers, the non-Muslim or Muslim who would be representing their client. Advocate Bava could explain like this would impact couples. Advocate Bava,
thank you, Mayat. I don't know. I think I've got a bit of instability on my side, and I wonder if you can hear me clearly.
I can hear you.
Okay. All right. So Order 1.8 is actually, like you say, the most fundamental and groundbreaking element of this entire order. I must say the case is groundbreaking and is a culmination of, like I say, many years of struggle. But Order 1.8 actually puts the aspects of the equality, the dignity and the access to courts in greater perspective. In that it says that the Divorce Act is in operation and applies to Muslim marriages. Now, this is fundamental. How does this impact on maintenance and eviction from the marital home? And in this regard, maintenance in respect of the spouse and maintenance in respect of the children are now all on par with all other maintenance claims by any person who typically was regarded as married in terms of the Marriages Act, and therefore all the provisions of the Divorce Act, meaning issues such as interim maintenance by a spouse or children, normally brought in terms of Rule 43, will now become applicable. Equality or in terms of cost orders, where, for example, a wife is deprived of, or Muslim wife is deprived of legal resources, where, for example, the divorcing husband withholds finance and uses finance as a power tool. An application can be brought to court to say that the husband must now finance that litigation, and that can be brought in terms of a Rule 43 claim. So it would not deprive the Muslim woman who is being divorced from having access to financial resources, which may ultimately turn out to be her own financial resources, but which are being kept away from her by the divorcing husband because he is using it in order to gain an advantage. The children will not be prejudiced. They will be entitled to maintenance claims. So if they've been living, and this goes back in terms of the old case of Ghani versus Ghani, which is still good law, where the courts have looked at what was the standard of living of the parties, and that was one of the factors that the court took into account. So as far as maintenance is concerned, it has far-reaching implications, and the same provisions that apply to all other marriages in South Africa now will apply to Muslim marriages. And this is a fundamental ground-shifting piece of I think, a development in terms of the common law. One that is, I think the Supreme Court of Appeal itself said 26 years too late. It should have happened in 1994, but it did not. And more particularly, Section 6 and Section 7 of the Divorce Act, dealing with maintenance and dealing with the rights of the spouse and the rights of children, are now highlighted to the stage where there is no unfair discrimination if you are a Muslim child or if you are a Muslim spouse going through a divorce. And as far as evictions from the matrimonial home is concerned, that would be the same principles that would now be applied, that are applied to other marriages, which were not regarded as Muslim marriages in the past. So to place this in context, prior to this, Muslim marriages were looked at because of a certain ethos and a certain understanding of judges in the apartheid era, that Muslim marriages, because they were potentially polygynous, that they were not on the same moral ground as other marriages, and more particularly taking from the Judeo-Christian perspective. This decision of the SCA now says all marriages, irrespective, if you're a customary marriage, irrespective, the common law and more particularly Muslim marriages, you are now on par. So whatever rights are afforded to every child in South Africa, to every spouse, and more particularly every woman who is married in South Africa, all people have the same rights and nobody is being discriminated against.
Okay, thank you. Shoaib, I'm going to ask you the next question, but before we get on to that, and we're dealing with proprietary consequences and so on later, but this 1.8 is so important. Is there anything you want to add to what Advocate Bava said or not?
Yes, let me just make a few comments. 1.8 is designed to grant the spouses in an Islamic marriage temporary relief or interim relief. So until the legislation, the contemplated legislation, either in the form of amendments to existing legislation or new legislation, is passed or enacted within 24 months. So it's a mechanism to grant interim relief. And obviously, that was one of the debates before the court. What would be the appropriate framework for granting interim relief to spouses who are in an Islamic marriage? So finally, the primary parties, that's the Women's Legal Center Trust on the one hand, the applicant, or in this case, at the level of the appeal court, the respondent and the state, both favored the application or the mechanism of the Divorce Act to give effect to interim relief, although there were different orders that had been submitted to the SCA. On behalf of UCSA, I had submitted a different order, similar order granting interim relief, but not using the mechanism of the Divorce Act. But the court favored the mechanism of the Divorce Act, because you've got an existing statute, and the statute already has provisions for safeguarding minor children, for provisions relating to the redistribution of property, more particularly in the context of a Muslim marriage, Section 7.3.
Yeah, we're coming to that. If I can go on to the next question.
Correct.
And we're dealing again, we're still on Order 1.8.
Yes.
Which, if they can just put it up on screen again, because this is the nub of what we're talking of today. Again, it's pending legislation. The Divorce Act applies to all existing Sharia marriages. In the absence of a contrary agreement, Muslim marriages are out of community of property, and the Divorce Act applies. Now, is a Sharia marriage with or without accrual in terms of the order? By linking the proprietary regime to the dissolution of the marriage, what is the proprietary regime until dissolution? Because in South Africa, persons who marry out of community of property under ANC are by default married with accrual, unless the accrual system is expressly excluded. By declaring all Muslim marriages out of community, has the SCA not imposed a marital regime that is contrary to the default Islamic law position? Should the SCA not have made its intention clear by adding just two words, either with accrual or without accrual? Or would you say that by stating that Section 7.3 of the Divorce Act applies, namely a just redistribution on dissolution of pre-1988 out of community of property marriages, the SCA has made its intention clear, put it beyond all doubt that it is ANC without accrual?
Yes, there are three parts to this part of the order set forth in Section 1.8. Three constituent parts. The first part is, and that was proposed by the state and supported by myself on behalf of UCSA, namely that the original Sharia law provision is that every Muslim marriage, every nikah, the original consequence of that nikah or Muslim marriage is that marriage is deemed to be out of community of property with the exclusion of accrual. So that's the original position, on the basis that whatever the husband owns belongs to him, whatever the wife owns belongs to her, right? That's the first part. The second part is then the order says, except where there are agreements to the contrary, and that part was also a part that I debated with the court, and I was quite happy with that wording, because that covers all the situations where husband and wife, through a process of joint consent, mutually agree after post-nikah, right, or at the time of the nikah, to enter into a different, if I can call it in inverted commas, partnership arrangement. And in the classical fiqh, we've got a number of partnership arrangements which are recognized in Sharia law, which can be concluded if those conditions are met between husband and wife. And we have the Inan partnership, we have the Mufawada partnership also. A Mufawada partnership is akin to a community of property, in terms of which the husband and wife enter into a partnership arrangement where they agree to share all their assets in equal shares, and they agree to be liable for all the debts of that partnership estate, jointly and severally. Then we have an Inan partnership, which is even more flexible, where the husband and wife can enter into a partnership arrangement in terms of which they could agree on sharing the assets of that they have acquired during the course of the marriage in whatever proportions they want. For example, the husband may agree to to share the assets in a ratio of 1/3, and the wife will get 2/3. Obviously, it means
Look, I
both
think
the profits and losses.
Yeah, an
So
agreement
that's the second part.
would be fine.
Yeah,
But
and can I just
what
tell
is
you
the effect
third?
of the judgment?
Okay, let me give you the third part of the judgment, the three parts I mentioned, the constituents. So the first part says that the Divorce Act will apply, the marriage will be out of community of property, except where there are agreements to the contrary. If the spouses enter into a contrary agreement, that will be given effect to. And the third part relates to a redistribution in terms of Section 7.3 of the Divorce Act, right? So this Section 7.3 is the famous redistribution provision of the Divorce Act. And in this context, what this means is if the husband and wife were married in an Islamic marriage, right, exclusively, which was not registered under the Marriage Act or any other legislation, and they had commingled their assets. In other words, the wife has made contributions to the estate, the husband has made contributions, the one has paid towards a mortgage bond, the other has paid towards the household furniture and effects and so forth. And they've built assets through joint contributions. Ultimately, at the time of dissolution, all these joint contributions are commingled. So if the parties cannot reach an agreement to divide their assets on some mutually equitable basis, then in that event, Section 7.3 will trigger in as an interim provision, pending the passing of appropriate legislation. And either spouse can ask for a redistribution of the estate, and the court ultimately exercises a wide discretion in making an appropriate apportionment of the assets between husband and wife. So these are the three parts to this part of the order 1.8. And then, of course, there's subsection C, which deals with the polygynous or polygamous marriages.
Okay, if we can go on to SCA Order 2.1, where the minister undertook to place in mechanisms for the master to resolve disputes relating to the validity of Muslim marriages or divorces for claims against a deceased estate under either interstate succession or maintenance of surviving spouses. Munirah, you've championed nikah contracts, which inter alia could deal with the proprietary consequences. Has this judgment made nikah contracts even more important? And although this part relates to the Pharaoh case, does paragraph 2 of the order have wider implications?
Well, let's just go back very, very quickly to what this specific part of the order is all about. And if we look at the Pharaoh case, then the Pharaoh case is obviously shedding some light on some very dark and grim issues that are happening within this particular aspect that we're speaking about, which is basically that we have no records when a party is married. Well, at least when they're married, we have a nikah certificate. Okay, so that's still fine. But we have no records when a party is divorced. And so that becomes a huge issue, because that was not only the issue in Pharaoh. If we look at the Hassam case as well, there was a huge sort of argument about whether or not she was in fact one of the spouses of the deceased at the time that he became deceased. So this idea of being able to ascertain or determine what is the status of a surviving spouse in terms of the marriage to the deceased person is quite important in order for the surviving spouse to actually ascertain and access the benefits from that estate. So yes, nikah contracts are a very, very important part of regulating proprietary aspects in the absence of recognition. So, you know, whether it's it's more important now or whether it was less important before, really, it's really important. And it's something we've been punting. I do it individually as Amal, that when you get married, and if you're only getting married in terms of a Muslim marriage, then please do a Muslim marriage contract. But here, this order is specifically dealing with an administrative issue. And so I'm not sure how the master on his own or her own is going to be able to do this. And I think that this is particularly one of the areas in which Amal can really make some inroads, and in assisting actually the master's offices to be able to get to a position where they can deal with how you actually verify Muslim marriages. And the Pharaoh case threw a light on a lot of the shambles that the Muslim community is in. I mean, in the last event, we actually had to get an affidavit from a social worker who confirmed, because Pharaoh was seeing the social worker, that in fact they had reconciled. So sometimes there's clarity about the divorce, and in the Pharaoh case, the children from the other spouse were confirming that in fact there was a divorce, but there is no record of the fact that the parties had reconciled. So all of this becomes really, really important in determining, is the spouse married at the time of death, in order to be able to access the benefits. And so we have to look at this. And I think this is a very important part of the order for those purposes, that in fact the master now has the responsibility of perhaps devising a regulation or some means of how they are going to actually determine whether or not spouses were married to the deceased at the time of the death.
Okay, we're still on SCA Order 2.1. The minister has undertaken to put in place mechanisms for the master to resolve these disputes that Munirah had spoken about. Advocate Bava, what procedures can the minister put in place for the master to be able to resolve these disputes regarding the validity of Muslim marriages and divorces for the purposes of interstate succession and maintenance of surviving spouses?
Okay, this is a very important aspect, in that it deals with the financial survival of children born of a Muslim marriage as well as the spouse. And what happens after a spouse dies, and the other spouse now has to seek to get financial, I don't want to call it compensation, but to obtain the finances that are available to an ordinary spouse where a partner has deceased. And in the past, what used to happen is that Muslim children and Muslim wives particularly were placed in a very invidious position, in fact, in a very unfair and undignified position. They had to beg, and they had no law to support them. Now what is happening?
What mechanisms do you envisage that the minister could put in place?
Well, I think, and this is where I want to get to, is that the minister doesn't have to put many mechanisms in place, because the way this judgment is written, it arms a person in terms of the common law and in terms of the application of the Divorce Act. And this is one of the aspects in the Pharaoh judgment that was defined by Judge Rogers in that case. And Judge Rogers had to decide what constitutes a spouse and who is a surviving partner. And in respect of both of those, he said those would apply to a surviving spouse in a Muslim marriage. Now the common law is developed, the Divorce Act is developed, so it makes the argument of any surviving spouse that much easier. And the minister, to my mind, does not have to impose any elaborate aspects, because the definitions as per the Supreme Court order would allow a surviving spouse to insist by way of right that accrual in terms of the estate be paid over to the surviving spouse.
Okay, if I could go on to the next one, we're looking at Order 1.1, and 1.8, which says marriages solemnized under Sharia law, union under Sharia law, marriages terminated under Sharia law. Now, it's an accepted rule that the court should not become religiously entangled. By using language such as marriages terminated in terms of Sharia law, has the SCA not opened up the floodgates to religious entanglement? There are differences in the interpretation of Sharia law, even within the four main Sunni schools. For example, the necessity of wali, which we dealt with earlier. Has a Frankenstein monster been created which the courts will not be able to manage? The SCA refers to marriages solemnized. Now, how formal must the offer and acceptance be to satisfy the SCA? Would a car park marriage be void? 666 advocate X declares a revocable talaq. The court dissolves his marriage. By resuming intimacy in the iddat period, X is again Sharia married. He issues a second talaq. The judge says, hang on, were you not in my court a few months ago and you don't have a remarriage certificate? Milady divorces him again. X resumes intimacy in the iddat period and thereafter issues a third talaq. Milady is fuming, but X says, chill, 3 strikes and I'm out. You'll never see me again, at least not with this wife. MS, in the absence of a legislative framework, have we weaved a tangled spider's web? Shoaib?
Well, yes, let me just add here. Thank you for that. The first thing comes back to to the initial point about the legislative framework. Of course, we need a viable legislative framework to regulate these issues, right? That is what is needed. And this currently, paragraph 1.7 states that the declarations of constitutional invalidity are suspended for a period of 24 months to enable Parliament to remedy the defects by either amending the existing legislation or passing new legislation within 24 months. So what we have here is just an interim relief in paragraph 1.8 deals with interim relief. Now, if we have the answer to your question, your question was there religious entanglement? My answer is no, because you're dealing with a Sharia law marriage. And if there's a dispute, for example, whether that marriage was validly contracted or whether the talaq had been validly issued or whether it was issued in circumstances where the husband at that point in time was effectively non-compos mentis or acted in an uncontrollable state equivalent to lunacy, for example. So there could be different permutations that may arise. But ultimately, if those disputes do arise, then the matter will have to be determined by a court after leading expert evidence. So this emphasizes the point we've been making all along, even in the context of the Muslim marriage bill, that we need a viable statutory system regulating Muslim marriages and their consequences so as to remove the ambit of disputes as much as possible and prevent a case-by-case development or case-by-case adjudication of issues arising from a Sharia marriage, which may lead to chaotic results, it may lead to uncertainty, and at the same time, it may not necessarily be Sharia compliant. But you cannot exclude the kind of problems that you've raised. Of course, these are realistic issues that may or may not arise in a particular case. But I think the bulk of the cases on an interim basis, all things being equal, will fall within if would fall within paragraph 1.8, which grants interim relief, namely where the marriage has de facto broken down irretrievably. The husband has granted a talaq to his wife, and the issue then arises that how does one resolve all the patrimonial issues flowing from that dissolution, firstly. Secondly, issues relating to maintenance, custody, access to the minor children for the wife, issues relating to redistribution of assets. So paragraph 1.8 was designed to deal with that within the framework and mechanisms of provided for in the Divorce Act, purely on an interim basis until the contemplated legislation is passed by Parliament as stated or as directed in paragraph 1.7 of the SCA order.
Yeah. Look, obviously I've raised extreme examples, but the point of the matter is that the bulk of the cases where there is oppression, there is injustice, are going to be resolved. And it also what you quite rightly mentioned, that legislation is required. If we're still on 1.8 of the order, again, pending legislation, existing Sharia law marriages. Now, that also includes marriages which were terminated in terms of Sharia. Legal proceedings have already may be dissolved under the Divorce Act. Now, Advocate Bava, by using the conjunctive and subsisting at the date of this order, could it be argued that Sharia marriages solemnized after the order are excluded?
Thank you for that question. I just want to qualify what I said in terms of my previous answer, and just to link it to Raid's answer. The point that I was making regarding the minister not giving directives was on an interim basis, to my mind, that is sorted out. Obviously, legislation is required for certainty, so that there is no misunderstanding and there is no diminishing the rights. And that is crucial. So that when legislation does get enacted, then it's a statutory right that everybody, all Muslim marriages or all Muslim persons who are in a marriage, including children, have as a certainty. And that's not then a development of the common law, but a statutory right. And that is crucial for certainty going forward. But in terms of this question now, is the use of the words "and substituting at the date of this order." That is very important, because this leads to an interpretation of a court order. And our law has been clear. I mean, there's a case called the Andomani versus City Health case, where they said, where the wording of an order and even a statute is clear and unambiguous, then that ought to be followed. What is the meaning "and substituting at the date of this order"? So if we are to look at the order as it is framed, it cannot be argued, in my mind, that Sharia marriages concluded or solemnized after the order are excluded, because there is already paragraph 1.8, which is applicable and which makes the Divorce Act applicable. And therefore, going forward, as from the date of the judgment, all Sharia marriages will then be subject to the Divorce Act. What it sought to do by saying "and substituting at the date of this order" was to make sure that those marriages that were solemnized prior to the order were not excluded. And because of, if you read, when one reads the judgment, the court indicated that when legislation comes about and the court cannot make a retrospective order, it is up to the legislature to decide. But in terms of this court order, it wanted to ensure that all Muslim women, children, and children particularly, who are in solemnized marriages as at the state of the order being granted, were afforded the protection in terms of the Marriages Act and in terms of them being spouses and children recognized. And therefore, it cannot be argued, to my mind, when one reads the order in its plain meaning, that Sharia marriages concluded or solemnized after the order are excluded from the.
Okay, thank you. Okay, we're still on SCA Order 1.8, which talks of pending legislation, existing Sharia marriages may be dissolved under the Divorce Act. Now, this webinar is not concerned with being whether pro-MPL or anti-MPL, but with the facts on the ground post the SCA order. Paragraph 1.8 makes the Divorce Act apply to dissolution of all existing Sharia marriages. Henceforth, can a marriage be dissolved only in terms of the Divorce Act, or is that merely a possibility by using the word may instead of may only be dissolved? Did the SCA give an option? Now, 666 advocate declares talaq, the wife accepts it, the entire Muslim community accepts it. Does 666 remain married until one of them gets a divorce dissolution order from the court? Now, Advocate Bava, again, is this not religious entitlement and to terminate a Muslim marriage?
Firstly, to my mind, and from reading the order, I think it's clear that it applies to the dissolution of all existing Sharia marriages. So irrespective, it has not left a gap, and the words may instead of may only do not allow a party to argue that that they can be excluded from this provision or this order of the Supreme Court of Appeal. You know, in interpretations, there are, for example, when may be read as must. And in this particular case, when you're doing an interpretational element, if somebody writes words in a very diplomatic sense to be nice and courteous, it doesn't mean that they are letting go of a right. And so the may in this circumstances, I think, must be read as a must. But let's go back and let's look at it, let's zoom out, as it were, in terms of a movie, and look at what is this, the entire Supreme Court of Appeal case. It is to give dignity back to the couple. It is to give dignity to people involved in Muslim marriages, including the children. And therefore, it seeks to secure those rights. And while talking on the aspect of dignity, I also want to take this opportunity, and I know that Emda Suti was with us, but I don't know if he is still. And I was very pleased to find out that the concept of dignity that was infused in our constitution was one of the elements that he vanguarded when the constitution was being written. And in his book, In Pursuit of Dignity, you find that this element of dignity was one that he had ascribed to for many years prior to that, and when the opportunity presented itself, he ensured that the concept of dignity was contained in the Constitution. So to him, we owe a huge debt, gratitude as well. And Ismail Mohammed's judgment in Ahmad, where MS Omar was involved, Ahmad versus the Multilateral Motor Vehicle Funds Act, also sought to promote the dignity as well as Justice Mosaneke in his judgment. So the short answer is that no, there is no escape route here for people who want to exploit a marriage situation between a Muslim couple, or as far as children are concerned. The Divorce Act applies, and the may as may must be read as must, and will therefore apply to all Muslim marriages.
Thank you. We're still on 1.8. Muslim marriages draft bill distinguish between a Muslim couple married by Sharia only and a Muslim couple married by Sharia plus civil law. The SCA order does not make such distinction. Now, 666 advocate is married both ways, sometimes called double jeopardy. He declares talaq Shuaib, if the Divorce Act applies, then is it correct to say that both the Muslim and civil marriage are dissolved upon a court order dissolving the Muslim marriage? Shuaib?
Right, Bismillah ar-Rahman ar-Rahim. I think we must make the fundamental distinction that I mentioned at the outset. This SCA judgment court order only applies to Muslim marriages or Islamic marriages which have not been registered as civil marriages. If you go to paragraph 1.1 of the order, it says the Marriage Act 25 of 1961, the Marriage Act and the Divorce Act are declared to be inconsistent with sections 9, 10, 28 and 34 of the Constitution of the Republic of South Africa, 1996, in that they fail to recognize marriages solemnized in accordance with Sharia law, in brackets, Muslim marriages as valid marriages, and again in brackets, which have not been registered as civil marriages. The whole case brought by the Women's Legal Center Trust for Relief and designed to compel the state to pass legislation recognizing Muslim marriages and their consequences for all purposes was premised only in respect of marriages concluded exclusively in terms of Sharia law or Islamic law, which were not converted to civil marriages. So to answer your question, if parties are married in terms of Sharia law and then they convert it to a civil marriage by registering their marriage in terms of the Marriage Act, whether in community or out of community of property, in their case, the civil legislation will apply and not the regime that we are discussing at the moment. Coming back earlier on to the point that Advocate Bava raised or mentioned, commented upon, in principle, I agree with him. Essentially, in paragraph 1.8, there are two situations insofar as interim relief is concerned, pending the enactment of appropriate legislation, either through amendment of existing legislation or the passing of new legislation within 24 months. The first situation is, firstly, this interim relief applies to all, as he correctly stated, to all current existing Islamic marriages which have not been converted into civil marriages. So every marriage, Islamic marriage, as we speak today, if the parties have contracted an Islamic marriage, a nikah, they have a nikah certificate, but they haven't registered their marriage in terms of the Marriage Act, that nikah will be regulated by the interim order. That's the first situation. And the second situation is where the parties were married in terms of an Islamic, were married in terms of Sharia law. That marriage was not converted to a civil marriage. And then there is pending legislation, pending legal proceedings. So, for example, one spouse in that marriage has already instituted an action for relief, irrespective of what the basis of that relief is, but arising from that marriage prior to the issue of this SCA order. So now that pending action will also be subject to paragraph 1.8. The parties in that pending action could amend their course of action and bring it within the framework of the Divorce Act. Previously, there was no mechanism to give effect to the incident of an Islamic marriage because there was no legal precedent for that, right? So when there were problems within an Islamic marriage, then lawyers used to be innovative by creating all kinds of causes of action, universal partnership, constitutional challenges, and common law constructs to try and achieve or to give effect to the incidents of an Islamic marriage. But now with this interim temporary, where the framework of the Divorce Act is now the preferred mechanism, in fact, is the mechanism, not the preferred mechanism, as Advocate Bava says, is effectively the mechanism to give effect to all disputes arising from the dissolution of a Muslim marriage. That's the one part. The other question you raised, I thought, was whether they are obliged to invoke the provisions of the Divorce Act. Well, you've got two situations. The one situation is where the parties enter into a sensible commercial settlement, right? So, for example, if you take a practical case, the parties are in an Islamic marriage, children are born of that marriage, the husband issues a talaq, it's accepted, the marriage has irretrievably broken down, and through a process of mediation, they enter into a settlement agreement where they regulate the patrimonial and personal consequences of that marriage. So once they enter into that agreement, then in my opinion, they can convert that settlement into an order of court in terms of the Divorce Act, right? Because now the temporary relief provisions in paragraph 1.8 makes provision for that. On the other hand, if they don't resolve their problems, right, and the dispute persists, then there's a mechanism now through the Divorce Act for either spouse to invoke the provisions of the Divorce Act to give effect to the incidence of that Islamic marriage, more particularly in relation to the property consequences, the maintenance consequences, and of course, most importantly, the welfare of minor children, which is entrenched in Section 28 of the Constitution.
Okay, if I could carry on. So some quick fire question and answers with Munirah. Still on SCA Order 1.8, the treatment of marriages out of community of property is linked to the dissolution of a Sharia marriage under the Divorce Act. Would it not have been preferable to declare that existing Sharia marriages are out of community of property? Munirah? Munirah, you unmute yourself, please.
Sorry about that. Let me just repeat what I was saying while I was muted. What I'm saying is that I agree with you on a first reading of that particular a part of the order, which is 1.8. It seems that they have limited this particular out of community of property regime to instances when the parties are seeking a divorce. So that is when a sort of more general order that was not couched within this particular order, that Muslim marriages will be regarded as out of community of property, would have a far more broad impact than it being only limited to instances of a divorce. And I think that that's quite an important aspect for us to consider, because if you look at the decisions of Farrow, Hassam, Daniels, etc., we were dealing with aspects of where spouses were wanting to actually access death benefits or benefits from the estate, etc. So of course, we do have the common law principles that have come through from Daniels and Hassam, etc., but we still need some kind of confirmation. So I agree with you that it's still very much limited in this particular order. I'm not sure whether we can argue for a broader interpretation if needs be, and if in this interim period while this order is going to be applicable, that we can actually argue for it to be applied in a more general sort of fashion.
But it comes back to the point you made earlier about the importance of nikah contracts. But going on to the next question, could a Sharia spouse claim community of property during marriage? And that's, I think you touched on it already.
Yeah, well, it also ties in with what Shuaib said earlier on. Then nothing stops Muslim spouses from actually entering into partnership agreements. And so in terms of that, it is open for them to agree that during the subsistence of the marriage, that they will share in terms of an in-community of property regime. So nothing stops them from actually, even if there's an accrual that is operating within the out of community of marriage system, that accrual could actually be that they're sharing in terms of 50-50, although the accrual is only access to the accrual portions and not the entire marital estate, as it were.
Okay. Could a creditor claim that there's a joint estate because they are legally married and by default married in community of property?
Well, if they are legally married, and because, as we've just discussed now, that this particular order is limiting the marital regime only in the instances of divorce to out of community, then I think that the creditor can very well argue that, in fact, this is a joint estate for whatever purposes, it doesn't really matter. And then perhaps actually, proceed to make the claims accordingly. So that's still very open. The order doesn't really deal with that particular situation or doesn't cover it or protect it in any way.
Okay, what is the marital regime of a Sharia marriage until divorce, which we've covered, and what is the marital regime on dissolution by death?
Well, I'm not too sure where this goes, but when we talk about on death, in terms of South African law, why we need to understand what is the marital regime on death is if the estate is an intestate estate. Then if it is an in-community of property marriage, then of course the wife is entitled to already her 50% and then entitled to the 50% of the husband's portion or the other way around. Or if it is out of community of property, then there are no such in-community of property claims. But if there is a will, whether it is an Islamic marriage or a valid civil marriage, then in that particular instance, the will clarifies. And of course, with most Muslims now, the trend is that they do actually make Islamic wills. And so in terms of an Islamic will, then the wife will get what is her particular share in terms of an Islamic will. So it's quite clear in that particular respect. The marital regimes are not something that is defined under Islamic law, Islamic Sharia law. We say that the closest to a Sharia position is the out of community without accrual.
Okay, previously the deeds office accepted either unmarried or married in terms of Islamic law. What would you think the proper citation might be now?
I think, Aslam, you're best placed to answer this question, although I'm going to try and answer it from my understanding. But if Muslim marriages are now, even for this period, recognized as common law marriages, then just married is going to be sufficient, in my understanding, that there's no now extra notation that you're married by Islamic law, because we're saying that the common law definition of marriage now is obviously unconstitutional to the extent that it does not recognize Muslim marriages. So if you are now married in terms of a Muslim marriage, then it's going to be cited as married. And I think we can debate this to a large extent, but that's my understanding of it.
Okay, if you put me on the spot, I would hazard a guess and say married in terms of Sharia, but until the registrar comes out with the ruling, it's the SCA order says that 1.7 declares the invalidity for suspended for 24 months. Now, on dissolution of the marriage, the welfare of minor children was not previously safeguarded. The redistribution, a just redistribution was not safeguarded, and there was no forfeiture of patrimonial benefits. Advocate Bava 4, which, as we said, are suspended for 24 months and subject to court confirmation. Advocate Bava, unmute.
Sorry.
Advocate Bava.
Yes, I'm here. Can you hear me? Hello? Hello, can you hear me?
Yeah, we can hear you.
We can hear you.
Yeah, okay. I was unmuted.
We can hear you.
Okay, thank you. I'm going ahead.
Yes.
Okay, so the firstly is the declaration of invalidity in paragraphs 1.1 to 1.4 are suspended for 24 months. We need to understand what that means firstly. What is the meaning of a suspension of an invalidity? So basically what the court has said is that we regard these aspects at 1.1 to 1.4, that the non-recognition of failure to recognize Sharia marriages as valid for all purposes and to regulate its consequences, and the protection of the welfare of the minor child or dependent child, the just redistribution of the assets and the forfeiture of the patrimonial benefits, if they do not apply to Muslim marriages, we regard that as being unlawful and invalid in terms of our law. But the court says we cannot make a final determination on this invalidity of the provisions of the section in terms of section 1675, as I said. Only the Constitutional Court may make that order of invalidity or declaration of invalidity. So what the court says is that those, although we find them to be wrong, we are going to suspend it for 24 months. But then comes the savior at order 1.8. And 1.8 is the savior in the sense that it says, but what happens in the interim? And the court says, no, but the Divorce Act will apply. And the other portion is that the common law marriages include Muslim marriages. So the implications of 1.1, which are suspended, will, in view of the fact that the interim orders have been granted, or the interim relief or determinations have been made by the Supreme Court of Appeal, the effect of it is that simply that it applies in terms of the common law and it is not a statutory right. So until legislation is passed thereafter, the interim position is that as far as the common law is concerned, and as far as the statutory right in terms of the Divorce Act is concerned, those apply to Muslim marriages. And in essence, it has, the Supreme Court of Appeal has taken into account that if orders 1.1 to 1.4 are suspended, how will Muslim marriages and people who are involved in Muslim marriages, particularly women and children, protected, and has therefore given as an interim measure these protections. So they basically stand in substitution, but they're not statutory rights as such, except that where the application of the Divorce Act is concerned, that would be a statutory right, but also then on an interim basis. And when the legislation is thereafter promulgated after 24 months or within 24 months, that those statutory rights will then be accessible to spouses, Muslim spouses and children.
Okay, Munirah, 1.7 says it's suspended until legislation is passed. Now, what legislation do you speculate government will pass? Do you see them passing a dedicated Muslim Marriages Act, or instead an Omnibus Umbrella Act? If it's an Omnibus Act, would it adequately cover the various religions and its complexities? You can hazard a way forward.
Tall order, Aslam.
Munirah?
I say it's a tall order. It's almost like writing a PhD, this particular question that you raised. But let's just take
short,
it,
because we don't, I need to hand over to Ashraf Parker shortly. Yeah.
Let's take it a bite at a time. Well, firstly, I think we must understand that all that happens in terms of what policy government is adopting with regard to how they're going to be recognizing and giving a recognition to the consequences or regulating the consequences of Muslim marriages. And so it seems that at this particular point in time, all the efforts in recognizing Muslim marriages in terms of a specific Muslim marriage legislation has been shelved. That is the current situation. So that whole swear word of MMB has now been thrown out the window. What government is basically pursuing is what they refer to as a single marriage statute. And this is being mooted and proposed by the Department of Home Affairs, who, because of the various different issues that they have had to deal with regarding the registration of marriages, et cetera, have proposed this a single marriage statute. Now, it's very, very difficult to actually say what's going to be the best way forward, because there's very, very little detail, if at all, available on what this a single marriage statute is actually going to contain. So for now, again, all it talks about is perhaps the government policy that they're looking at one marriage legislation that will cover all types of marriages that exist in South Africa. So that means that in this huge house of marriages, there'll be one room, I think, that will be dedicated for Muslim marriages. But even if we're saying that there's one door that's going to lead you to Muslim marriages, we don't know whether there's going to be a list of generic requirements for marriages on the whole, and then anything special for the various different types of marriages. But all I can speak of is what is happening currently, and that's what is on the ground at the moment, that we're waiting now for at least a first draft of the single marriage statute bill to see what some of those details will be and how they will actually operate.
Okay, thank you. I'm eating into Ashraf's time, so I need to move on very quickly. I'll make this my last question. MS, would you support giving every Muslim couple freedom of choice? Namely, if you marry by Sharia and then the civil law marriage only is recognized by the law. If you marry under a Muslim Marriage Act, only would apply. If you married by Sharia only, then the law must state that you are married, but that you do not receive any legal consequences from such Sharia marriage, which gives a democratic choice to each person and removes all legitimate opposition from any side. Now, MS, you've got, I think, just about 10 years to respond to this final question. Given the protracted historical acrimonious passage of MPL, how will government be able to enact legislation that will find acceptance in the Muslim community? Yes, it just rams anything down our throats to comply with the 24-month SCA deadline. A short answer, please.
Yes, just in a summary,
Yes.
I think the democratic choice is the best choice. Parties can remain married in terms of Sharia law without contracting a civil marriage. Parties could contract a Sharia law marriage and convert it into a civil marriage, or parties can buy in to any legislation if and when that legislation is enacted. But we don't know. The 24-month period is there, but having regard to the protracted and at some points acrimonious debates that were raging in respect of the old MMB bill, whether the 24-month period in respect of the current, in terms of this paragraph 1.7 of the SCA order will be met or not is another issue, because there may be lots of issues. And who knows, the state may have to go back to court to try and get an extension of the period. But in the meantime, the most important thing is the interim relief is in place. Sorry, Aslam?
Yeah.
In the meantime, the most important thing is the interim relief.
Para 1.4 will apply. Yeah, correct. Interim relief applies. But pending legislation, if legislation is not passed, then these para 1 comes into effect after 24 months.
You're talking about, no, this paragraphs 1.1 to 1.4 are subject to confirmation by the Constitutional Court. And the Court will confirm this within the next year. So,
correct, but 1.8 would come into effect after 24 months if legislation is not passed.
No. 1.8 is in effect with immediate effect. So it says there, 1.8 says, pending
correct.
the coming into force of legislation or amendments to existing legislation, it is declared. So the interim relief as we speak
Yes.
now is in force in terms
if legislation is not passed, it remains.
it remains, correct.
Yeah, okay, that's it.
So that was the whole idea of the interim relief, is to provide the interim relief pending the promulgation or enactment of legislation. So that will continue
Thank you very much.
until the new legislation comes into force. Thanks.
Yeah. Okay. Thank you to my panel. You've got to remain because Attorney Ashraf Abdul Rahman Parker of A. Parker and Associates is an EXCO member of Amal and head of the Cape Town branch of Amal. Ashraf will conduct the listeners' Q&A, and I hope people have put in lots of questions. I can see that they have. You can please put in more questions. Ashraf will be followed by our vice chair. Now, we pray that if not re-elected this year, our chair and vice chair will hand over power quietly without a fight. Over to you, Ashraf. Unmute yourself, Ashraf, and put your video on, please.
Assalamu alaikum, and good morning to all our colleagues that have joined us here. Just before I come to the question and answer session, I just want to extend a very warm welcome to one of the heads of our Chapter 9 institutions, Advocate Mohammed Shafi Amir Mia. And I just want to briefly read out a small comment that he posted, where he said that lessons learned from this important case, it demonstrates that in addressing in matters in the public interest affecting communities and their rights, dignity, equality, and freedom to enjoy the fruits of freedoms of democracy in our country by becoming active citizens and leverage the corridors of power to access to justice through strategic collaborative partnerships with the constitutional bodies that encourage citizens to join hands and fight for their rights. Now, we've had a number, thank you, Advocate Shafi Amir Mia. We've had a number of questions that has been posted. Some have been mailed as well. I'm not sure that the time is going to allow us to answer all of them, but we will try to the best of our ability. It may be that some of your questions have already been answered by the panelists who have responded to the questions posed by Aslam Mayat. But one of the questions that came through much earlier was that in light of the judgment, are we able to draft post-nuptial agreements, not necessarily notarially executed agreements? And the question goes further. If there is a breach of such an agreement, will the one party be able to sue on it, or is she required to bring the onerous application to court to prove the contract? So that's the first question I want to put to the panelists. And anyone is free to answer that question. I don't know if MS Omar would want to have a first go at it.
Yes. Basically, if in the light of this judgment, more particularly clause 1.6, where the common law definition of marriage is declared to be inconsistent with the Constitution and invalid to the extent that it excludes Muslim marriages. In my opinion, all post-nuptial or even prenuptial contracts entered into voluntarily between prospective spouses or spouses within an existing Islamic marriage, the provisions will be valid and enforceable. So I don't, you can just enforce those provisions and sue on those provisions, in my opinion. There should be no problem whatsoever.
Thank you. Thank you, Amos. I think that answers that question. The question I want to pose to Advocate Bava, I think this falls within his field of expertise. If the aggrieved party is able to institute a summons based on the breach of a contract, will an ordinary court deal with such a case as in all other matters? And where the matter is defended, will special courts not be a consideration and preferably a mediation panel of practitioners be appointed to deal with claims expeditiously and to comply with a court-annexed mediation. Advocate Bava?
Yes, I think that's an interesting question, but I don't think firstly that there ought to be a special court, particularly for Muslim marriages, if that is the implication. As far as special courts for divorces, there is already that in existence. So Muslim marriages will then be part of the of being subjected to the overall system that already exists. And Muslim people who seek to get divorced in terms of Islamic marriages will then be subject to the same rules that other parties are currently. And included in that is, you know, that there is the Mediation Act, and now more particularly in terms of all litigious matters, there is a Rule 41 capital A, which has come into enactment last year, March, which forces all parties to pursue the route of mediation. And so mediation is to the first port of call. In fact, when you do issue a summons, a sheriff will not serve your summons until the Rule 41A notice is duly signed, indicating that you have attempted to mediate the matter prior to resorting to litigation. And this is crucial. So mediation is going to be playing a huge role in divorces.
Thank you, Advocate Bava. I'll now move to some of the other questions, and some people have posted a few questions, but I think in fairness to others as well, we'll try and answer one or two of them so as to give everybody an equal opportunity. A first question, and it is, Salam, what exactly was the impact of non-recognition of Islamic marriages? And to follow that up, what exactly is the effect of recognition now of Muslim marriages? Can I put that question to the panel?
Well,
Munirah?
Okay,
Mr. Omar? Okay,
no,
Munirah?
that's fine. Let Munirah speak first. And then
well, I can talk to the first one, which is what is the impact of non-recognition. I think that's the whole history behind why we were mooting and asking for legislation to regulate Muslim marriages and to regulate the consequences thereof. It is because of the problems that exist on the ground. So, and lots of those problems have come up in the cases that have come before the court. So, for example, the case that was mentioned by Aslam Bava, the Ahmad case, is basically telling us that before the Ahmad case, a spouse married in terms of a Muslim marriage only was not regarded in our South African law as someone who could be able to access benefits from the deceased estate. And this wasn't so much a deceased estate, sorry, let me correct that, but rather that she could make a claim because she was his dependent. So the RAF, or the Road Accident Fund, basically accepted the claim of the children of the deceased Ahmad, but did not recognize the claim of the wife as a dependent, because they said she was only married in terms of Islamic law and therefore was not regarded as a spouse. And that basically gave us a new common law principle that there exists between monogamous Muslim spouses a duty of support. So that's one case that shows us why we needed to regulate and why we needed to recognize. If you look at some of the other cases like Daniels and Hassam, and Pharaoh, to a large extent dealt with accessing deceased estate benefits. Balance versus Idros was all about how you can access maintenance, and that maintenance which is due during the subsistence of the marriage. So all of these cases are basically showing to us that there's something problematic on the ground. Now, besides those cases that have come before the courts, there's a plethora of issues that plagues the Muslim community when it comes to terminating Muslim marriages. So lots of the times when the husband is refusing to grant talaq, the wife isn't able to really successfully obtain a fasakh for various different reasons, for the way it is not regulated, for the way it functions in the community, etc., etc. And then there's a whole issue with polygynous marriages amongst the Muslim community, which also requires some kind of regulation at some point. So all of these have given rise to the fact that we need some kind of, well, on the one hand, we need recognition, but we also need regulation of the consequences. So I think, Shoaib, you can speak to the second question, which is what will be the impact of there being recognition of Muslim marriages?
Yeah, I think that answers the question. The non-recognition of Muslim marriages has produced very serious hardships and difficulties on the ground, more particularly for women who were disadvantaged. And there was, all that we had was case by case, piecemeal development. Whenever there was a serious problem, and if there was a challenge, then the court had to develop and provide relief based on the facts of that individual case. Now, in the light of this judgment, there will be a recognition of Muslim marriages and their consequences for all purposes. So, obviously, pending the legislation that is accepted, is contemplated in paragraph 1.7 of the order. And just to repeat what we stated earlier on, an interim statutory regime via the Divorce Act has been created to provide for relief, more particularly in the context of the termination of Muslim marriages and the consequences that arise from the termination of Muslim marriages, including maintenance, custody, access, and the division of property.
Thank you, MS. And Munirah, Assalamu alaikum. Shukran for this wonderful initiative. While I understand that the Supreme Court of Appeal recently has ruled that all Muslim marriages in existence are to be considered outer community of property, please advise, given the above, as well as the fact that amendments or new legislation are yet to be promulgated, do legal practitioners still encourage Muslim clients to execute antenuptial contracts to ensure their marriages are, I think, would be outer community of property as a precautionary measure? What would be the advice in such a scenario? MS?
Yes, I think it would be safer for Muslim practitioners to actually get prospective Muslim spouses either to execute an antenuptial contract or to execute a bilateral contract. It need not necessarily be an antenuptial contract which will be registered in the deeds office per se, because that, I think, will be regulated by the legislation which is anticipated within 24 months. But at least a bilateral contract between the spouses regulating their matrimonial property regime and other matters that they deem expedient by way of mutual agreement to regulate in terms of that contract.
Thank you, MS. Just the next question. Will the Islamic marriage certificate be sufficient proof of the existence of the Islamic marriage, or does the legislation intend to require Islamic scholars who conclude the Islamic marriages to register the marriages with the Department of Home Affairs? In other words, the Islamic scholar or marriage official become a marriage officer as defined in the SAL. I do think there are, just to, if I may answer that question, there are many Islamic imams that have been recognized as marriage officers, and they also execute and the civil marriages in which they subsequently register with Home Affairs. But the question says, just will the Nikah marriage certificate be sufficient proof of the existence of the Islamic marriage, or do you think that the legislator might intend to require our imams to conclude these marriages to register the marriages? So in other words, does the Islamic scholar or the marriage official become a marriage officer as defined in SAL. MS or
yeah, that we'll have to wait for the legislation. I have no doubt that the legislation that will ultimately be enacted by Parliament will provide for registration of Muslim marriages, for marriage officers, similar to what was contemplated in the draft Muslim Marriages Bill. So there will definitely be a process of registration within via Home Affairs.
Thank you, MS. Aslam Bava, given the concerns with dignity that you raised, would you consider that what remedies might we imagine as possible relief for the women that have been without constitutional protections over the last 26 years, who have terminated marriages of 20, 30, or even 40 years without any of the protections now envisioned by the new ethos that this judgment brings? Advocate Bava?
Yes, so this is a very interesting question. The question primarily relates to issues such as women who were married previously and who were not afforded the protection that is now afforded in terms of the Supreme Court of Appeal case. What happens to them that they suffered in the past? And the Supreme Court of Appeal was very cautious in dealing with the retrospectivity and also with the separation of powers in its judgment. And it went to great lengths to say that the Supreme Court of Appeal cannot make something retrospective meaning applicable to the past situations, and that is left up to the legislature. And it did not want to interfere with what Parliament or the President and Parliament have to pass as part of legislation. So it did not want to entangle itself. Currently, the way I read the Supreme Court of Appeal case is that it does not afford rights to people who have already been divorced, and it only affords rights to people who are currently in marriages, and if they do get married or if they get divorced, is from the date of judgment, and those marriages that subsist or subsisted at the date of the order being granted.
Thank you, Advocate Bava. In an interstate estate, the master refused to accept a nikah certificate, but insisted on a marriage certificate issued by the Department of Home Affairs. Hence, the Muslim wife was not exempted from providing security. Will she be able to register the nikah at the Department of Home Affairs? MS, I wonder if you could come in.
No, at the moment, in the light of this judgment, this problem gets resolved because the judgment has to be forwarded to the Master of the High Court. And if you look at paragraph 2.1 of the judgment, that also provides that the Master of the High Court should formulate procedures to regulate disputes relating to the validity of an Islamic marriage, of a Sharia law marriage, in the context where the wife brings a claim for maintenance under the Maintenance of Surviving Spouses Act, or claim for benefits under the Interstate Succession Act. But of course, once the legislation, the contemplated legislation is passed, then the legislation would be overriding and would govern the situation. But in the meantime, I think on an interim basis, until that legislation is passed, this judgment would then be the authoritative legal authority that will govern the situation that you have mentioned.
Thank you. Thank you, Ms.
Can I
Munirah,
add one comment here? That in fact, the Daniels and the Hassan case actually developed the common law on this principle. And so I can't understand how an Islamic marriage certificate would not suffice to say that they are spouses in a Muslim marriage, because the common law principle, and there should not be a need to now show that they are registered in terms of a civil marriage, when the common law principle is that spouses in a Muslim marriage are able to access in terms of the Interstate Succession Act, as well as the Maintenance of Surviving Spouse Act.
Thank you, Munirah. Yes, I agree. I think within time, Home Affairs in particular will have to seriously educate some of the officials with regards to this judgment. But I'm sure going forward, it will and hopefully filter down. Just a further issue on the question. Somebody posed a question here, and again, it's addressed to MS, but I think it's a general sort of question, and to Amal as well. You know, as a guidance to practitioners, can Mr. Omar and Amal provide sample contracts? I think for the time being, one has to just park that. I don't think that is the intention at this stage for the purpose of this webinar. Offer different options that practitioners can utilize in regulating Islamic marriages, given that there is uncertainty as to the status of marriages being in or out of community property. And the question to Mr. Omar is, can these agreements now be entered into with existing Muslim marriages? MS?
Yes, the answer is yes. The
Okay.
parties can enter into bilateral agreements to
Thank you,
regulate the incidents and property consequences of the marriage.
Okay. Just Advocate Bava, if you could just maybe put something to you. One of our members posed a question concerning the issue of mediation panels, stating that this person has always been a grand supporter of settling matters and seeing the need for a mediation advisory panel. Should we not at least grab this opportunity, especially as Muslim practitioners, to set up a mediation panel? Because some ulama bodies might not possess the legal training to be able to deal with the legal and factual issues. Should Amal, for example, not consider setting up, not only Amal, perhaps other bodies as well, such mediation panels? A uniform training for such mediators who, once certified, could also be appointed by court where the parties fail to seriously explore mediation prior to going to court. Advocate Bava?
Thank you for that question. I think it's a very important thing. I think it is what Commissioner of the South African Human Rights Commission has also mentioned as being proactive. I think it's a fantastic idea. I think that there is huge opportunity for legal practitioners. And I would like to suggest that what we do here is perhaps in view of the fact that there is the indication that ulama bodies may not have the necessary qualifications. I want to put it as broadly as this, that within the ulama body, there is expertise that they do have, and within the legal fraternity, there is expertise that the legal fraternity has, which is in terms of South African law. I would ideally see a convergence and a collaboration between the ulama bodies and the legal practitioners to form or to inform each other of what their skills are, to educate each other, and to create a platform where a person who goes to such a mediation panel is then assured that they will get the expertise both in terms of Islamic, of the Sharia, and in terms of South African law. And if we can manage to do that, that collaboration, to my mind, will be a fantastic step forward.
Thank you, Advocate Bava. Just in conclusion, there are a number of questions, unfortunately, due to time constraints, that we couldn't answer. I clearly am of the view, and I'm sure I echo the sentiments of the rest of the panelists and Amal, that within time we should perhaps consider setting up and sharing another webinar. But in conclusion, I want to convey a comment by Enver Surti, was a minister in government, thanking us for the excellent discussion, stating that the MPL Act could have been passed more than a decade ago, but the difficulty was to get consensus from the Muslim community. Shouldn't a dedicated effort be made to achieve consensus in order to assist the minister in developing the appropriate mechanism that would favor the broad Muslim community? I remember that we were on the cusp of passing legislation a decade had it not been for division of opinion. So, Mr. Surti, thank you for your comment, and I'm sure going forward, that will certainly be taken into account. In conclusion, I apologize for not being able to host and answer all those questions, but I'm sure, as I said, we will do it hopefully at a later stage. You are also obviously free to mail Amal, and I'm sure we will be able to share these questions with members who will be able to assist you going forward. I wish to pass over to Zain Fakhruddin, who's an attorney. Zain is the Deputy Chairman of Amal, based in Durban. He has served Amal and many other bodies for a number of years to pass the vote of thanks. So over to you, Zain. Thank you.
Thank you so much, Ashraf. Can I be heard? Ashraf, can you hear me?
Yes, I can hear you. Go ahead, Zain.
Thank you. But firstly, I think this was an excellent webinar, highly impressive. And I think the participants have learned a great deal like I did. So from our side, from Amal, on behalf of the chairman and the executive and management of Amal, a sincere thank you to each and every one of you that participated this morning. I must start off by commending Aslam Mayat, who almost single-handedly did all the preparatory work heading towards this webinar. Lots of notes were shared early in the last week or two, lots of preparation, and that shows the early, the early learning that we got when we were in university. We were told the best lawyer is the one who prepares the most. And I think Aslam did a brilliant job in his preparation. It showed in this webinar. He prepared all and sundry, specifically the panelists. I think from our side, really, we are duly indebted to him for putting this webinar together. The panelists, MS Omar, our senior lawyer of Durban, Munirah Osman, senior lecturer from Metal University, KZN, Advocate Bava, SC, senior counsel from Johannesburg. I think you all did an exceptionally top job. The presentation covered, I think, a very complex aspect of our law arising out of that recent judgment of the Supreme Court of Appeal. I think you'll covered almost everything that I had queries in my own mind when I saw a summary of that judgment. And really, MS, Munirah, and Aslam Bava, really you'll have greatly educated us big time this morning. And we are deeply indebted to all of you all. Ashraf Parker, as usual, very professional, how you handle the question and answer session. I'm sure there's much more questions that had come through, but I think you picked out the important ones, and it was well answered by the panelists. As far as the participants, there were 123 on my last count. A great appreciation to making this webinar a success. Without the participants, there can't be a webinar. So thank you for setting aside valuable holiday time. It was a Saturday morning, and it was, I think, well spent. And we are now much more educated, much more informed before 10 o'clock this morning. I think the panelists, we owe them a great favor. And you, the participants, thank you so much for participating. On behalf of Amal, thank you very much. Jazakallah khair. Our deep gratitude once again to each and every one of you that made this webinar a huge success. I'm certain in my mind that many are going to be asking for the recording of it. I, for one, the first thing I'm going to do, actually, I thought of actually inviting Munirah to my office to, there are some members of our staff who deal with this aspect of the law. I see two of them are not available, to perhaps educate us a little more, guide us and through this very complex, not complex, but there were various difficulties that I had experienced when I was trying to get through this quagmire, this judgment in relation to the legislation, etc. So, but thank you very much once again. Take care and all the best. Lastly, Ashraf, if you'll allow me, and Aslam Mayat, if you'll allow me, there was a comment made about mediation. Some 8 or 9 years ago, I raised it at executive level that it is imperative that we have a mediation council. And I cannot agree more with Aslam Bava that was exactly what our thinking was, that we have a partnership with the ulama, and there are many who are experienced in this field, and there are many experienced lawyers amongst us, like Faisal Bulbulia, who was part of Amal Muhammad Isak and others who specialize in this field, to definitely set up this mediation council, not only provincially but nationally. Jazakallah. Thank you so much, Ashraf, and thank you, Aslam Mayat.
Assalamu alaikum.
Walaikum salam wa rahmatullah. Aslam, will you close the session?
No, you in charge. I'm out. I'm finished. My job is done.
Okay, thank you. All the best. Assalamu alaikum wa rahmatullah, and a good afternoon to all participants and the panelists. Thank you very much for the last time. Assalamu alaikum.
Salam. Barakatuh.